Well, for many, estate planning also includes planning for the possibility of long-term health care. A recent court decision from Iowa raises concerns about protecting assets in a trust from a state's reimbursement claim of Medicaid benefits. Roger McEowen with the Washburn School of Law joins us now with further perspective on the situation. And Roger, as always, thanks for your time. Certainly a concern as our farmers continue to age and the population gets older. So let's start with some of the basics of Medicaid. Roger.
Well, good to be with you, Janet. You're right. This is a major component of many farm and ranch estate plans, or at least should be considered by many, because often the goal is to keep the farm or the ranch in the family from generation to generation, or at least the subsequent generation immediately. And we don't want to lose the land and the assets to pay for a long-term care bill. And that's where Medicaid comes into play. That's a joint state-federal cooperative program, but in order to go on Medicaid, you can't have very many assets or income. And so the whole idea is what can be done from an estate planning standpoint to shelter those assets, to protect them from being depleted, paying for a long-term care bill.
So the case out of Iowa, that involves, from what I understand, an asset sheltering trust. What exactly does that entail?
Yeah, this is a special type of trust that has a clause in it that basically says the trustee has complete discretion not to pay any of the income or the assets from the trust over to a specified beneficiary for that beneficiary's life. And the idea is if that beneficiary happens to have a long-term care bill, goes on, ends up in a nursing home, that the assets in the trust don't give the beneficiary any right. And so the trustee can ignore them, and therefore those assets in that trust for the beneficiary are sheltered from a state's reimbursement claim after the beneficiary dies, which is exactly what the state of Iowa did in this case. They claimed that over the 48 years between the death of dad and the death of the daughter, that the brother, the son who was the trustee, didn't pay her anything out of the trust. And the state said, well, we think the trust was ineffective to shelter those assets. And so now we want reimbursed for all the Medicaid benefits paid on her behalf.
So, Roger, what would you say is the big takeaway from this case, and of course others I'm sure that are similar you've seen?
Well, the trust didn't work, and the court did allow the state to seek reimbursement from the assets in the trust. I think the big takeaway is that even though there was a strong dissent in the case, and the case could be appealed, that this is a very difficult and very technical area of the law, and these trusts have to be drafted very precisely and carefully. And so this is a long-range approach. You have to think about this ahead of time. You have to plan for it, and then you have to deal with and work with a practitioner that has experience in this area, so that the drafting is done very carefully and precisely on these trusts, so that you do end up saving the family farm.
All right, Roger, as always, thank you very much for your insight this morning. Roger McEowen, he's with the Washburn School of Law, connecting with us. Of course, you can go online to washburnlaw.edu for more information.